We're now in mid-February 2026, and thousands of gun owners across America are already committing federal felonies without knowing it. Some of these people have been breaking new federal sentencing guidelines for 3 months now. Others violated Kentucky's new red flag law 2 weeks ago, and in about 5.5 months, Colorado gun owners will start getting arrested for taking possession of firearms without state-mandated permits they didn't know existed. This isn't speculation about bills that might pass someday. These are enacted laws with implementation dates that have already arrived or are coming in weeks and months, not years. Major gun law changes swept through federal and state systems while most Americans were distracted by elections, holidays, and the daily grind of life, and now the enforcement apparatus is active and building cases. From the NFA tax stamp elimination that happened on January 1st but still requires full federal registration, to red flag laws that stripped Kentuckians of their firearms without due process starting February 1st, to training mandates in Colorado that take effect this summer, the regulatory framework governing gun ownership in America fundamentally changed in the last 4 months, and most people carrying concealed have absolutely no clue. And the worst part is that ignorance of these changes won't protect you when federal agents or state police show up at your door. The ATF doesn't care that you didn't know the sentencing guidelines changed last November. Colorado prosecutors won't care that you didn't know about the training requirement. Kentucky courts won't care that you didn't know your ex-girlfriend could file paperwork that strips your gun rights in hours. The government is counting on your ignorance because that's how they turn law-abiding citizens into criminals overnight. If you want to stay ahead of these changes instead of getting crushed by them, hit that subscribe button right now, because this is one of the only channels tracking these enforcement mechanisms as they activate instead of waiting until someone gets arrested to tell you about it. Drop a like if you believe gun owners deserve honest reporting about what's actually happening. And comment below with your state, because if you're in Colorado or Kentucky, you need to understand what's already in motion. The timeline is real and the consequences are severe. Let's start with what happened on January 1st, 2026, which is now 6 weeks in the rearview mirror. The $200 NFA tax stamp fee was eliminated. This covers suppressors, short-barreled rifles, short-barreled shotguns, and other items regulated under the National Firearms Act. The fee is gone. You save $200 per item. Gun rights groups celebrated this like some kind of monumental victory, and the firearms industry has been running promotions ever since. But here's what nobody's being straight with you about. You still have to register everything with the ATF. Every single item. The registration requirement didn't budge an inch. The federal government still maintains a database of every NFA item you own, where you live, your fingerprints, your photographs, your complete background check information. They still control the approval process. They still decide whether you get to exercise this supposed right. The only thing that actually changed is they stopped charging you $200 for the privilege of being monitored and controlled. This was signed into law back in July 2025 as part of what politicians marketed as a comprehensive firearms reform package, and Second Amendment organizations acted like they'd won some historic battle. But walk me through what we actually gained here. The financial barrier dropped, which is fine, but every mechanism of federal control remained completely intact. The registry exists, the waiting period exists, the approval discretion exists, and the federal felony for possessing an unregistered NFA item exists with the exact same 10-year prison sentence and $250,000 fine it always had. So what did we really win? We won the right to submit to federal surveillance for free instead of paying for it. That's the victory. That's the reform. And here's where it gets worse for people who didn't pay attention to timing. If you submitted a Form 4 application in November or December 2025 with the $200 fee already attached, that money is permanently gone. The ATF is not issuing refunds. They took your money for something that became free 6 weeks later, and there's nothing you can do about it. If you're planning to purchase an NFA item now and somehow haven't started the process yet, at least you'll save the fee. But make absolutely certain the Form 4 submission happens after January 1st, not before, or you're just throwing money into a federal black hole. And understand this clearly, while the federal fee disappeared, state laws didn't change at all. California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, Hawaii. Suppressors remain completely illegal in these states regardless of what federal law says. The fee elimination is irrelevant if your state treats possession as a crime. You're still going to state prison if you get caught. And even in states where NFA items are legal, ATF processing times are exactly the same as they were before. You're still waiting 90 to 180 days for Form 4 approvals. Eliminating the fee didn't make the bureaucracy any faster or more efficient. You still submit fingerprints, passport photos, and endure a background check. You still wait months in limbo. The only difference is you're not paying $200 for the waiting experience. Here's the bottom line that should make every gun owner pause. This fee elimination is a minor financial benefit wrapped around the exact same authoritarian control structure that existed before. The ATF still owns the entire process. They still maintain the registry. They still have complete discretion over approvals. And if you possess an unregistered NFA item, because you thought the rules fundamentally changed, you're still committing a federal felony carrying a decade in prison. They will still prosecute you with the same aggression they always have. The fee is gone, but the control infrastructure is stronger than ever. Don't mistake a small financial break for actual freedom. And while we're discussing federal prosecution, we need to address something that's been active for over 3 months while almost nobody noticed. On November 1st, 2025, the U.S. Sentencing Commission amended federal sentencing guidelines for firearms offenses. That date is now more than 3 months behind us. This isn't coming anymore. This already happened. And penalties for straw purchases, false statements on Form 4473, and illegal transfers just became significantly more severe. And the vast majority of gun owners have no idea these changes are already being enforced. A straw purchase happens when you buy a firearm for someone else who legally cannot own one. Maybe your friend has a felony record. Maybe there's a domestic violence charge. Maybe they use marijuana recreationally and can't pass the background check, so they hand you cash and ask you to purchase a gun on their behalf. That's a straw purchase under federal law. It's a felony. Before November 1st of last year, you faced up to 5 years in federal prison for this. Now, under the amended sentencing guidelines that took effect 3 months ago, you're facing up to 10 years. The penalty doubled, and the ATF is investigating these cases right now with an intensity that should genuinely frighten anyone who's ever been casual about how firearms change hands. They're cross-referencing Form 4473 submissions with financial records, text message metadata, surveillance camera footage from gun stores, social media activity, everything they can access. In 2024 alone, the ATF prosecuted over 300 straw purchase cases. That number is climbing in 2026 because the penalties are now severe enough that federal prosecutors are making these cases a priority. 10 years in federal prison gets their attention and gets resources allocated. This is active enforcement happening right now. And there's another way people are walking straight into federal charges without realizing the ground shifted under them, lying on Form 4473. Question 21E on that form asks whether you're an unlawful user of marijuana or any controlled substance. Even if marijuana is completely legal in your state, even if you have a medical card issued by state authorities, marijuana remains federally illegal, period. If you consume marijuana in any form, and you check no on that question, you just committed a federal felony. Under the sentencing guidelines that took effect last November, that's up to 5 years in federal prison, increased from the previous 2 years. And the ATF is actively cross-referencing Form 4473 submissions with state medical marijuana registries in jurisdictions where that data is accessible through legal channels or data-sharing agreements. They're reviewing DUI records, they're examining drug possession charges, they're monitoring social media. If you post a photograph on Instagram or Facebook showing marijuana use and then purchase a firearm 2 weeks later, ATF investigators can and will use that social media post as evidence that you lied on a federal form. This is not theoretical enforcement. This is happening right now, today, as federal agents build cases using digital evidence that people voluntarily posted online. So what do you actually do to protect yourself under these harsher guidelines? Never purchase a firearm for someone else. Ever. Even if they provide the money up front. Even if it's your brother, your closest friend, your spouse. If that individual cannot pass a background check on their own, you cannot legally buy a gun for them under any circumstances. This is not a gray area subject to interpretation. This is explicit federal law, and the penalties just doubled to a decade in prison. When you complete Form 4473, answer every single question with complete truthfulness. The ATF has extensive databases and interagency access. They will discover false statements eventually, and when they do, you're looking at 5 years under the new guidelines instead of 2. If you're planning to gift or transfer a firearm to a family member, understand the specific legal requirements. In most states, you can transfer a gun to an immediate family member without processing the transaction through a federally licensed dealer. But that recipient must be legally permitted to own firearms. If they're a prohibited person, if they have any felony conviction, any domestic violence record, if they use federally controlled substances, you cannot give them a firearm. That transfer is still illegal under federal law, and under the amended sentencing guidelines, you're facing serious prison time. The bottom line here is brutal and simple. The ATF is intensifying enforcement on straw purchases and false statements on federal forms. The sentencing guidelines that took effect 3 months ago mean substantially longer prison sentences, and federal prosecutors are taking these cases more seriously than they have in years. Don't risk 10 years in federal prison because you thought you were helping out a friend or because you didn't think one question on a form mattered. The government is counting on that casual attitude to rack up convictions. Now we need to address Colorado because there's a mandatory training requirement taking effect on August 1st, 2026, and if you live there or plan to purchase firearms there, you have less than 6 months to prepare. This requirement emerged from Senate Bill 3, which was signed into law in April 2025. Starting August 1st this year, anyone purchasing a semi-automatic firearm in Colorado must complete a state-approved safety training course and obtain a permit before they can legally take possession of that gun. This doesn't technically ban specific firearms. You can still buy AR-15s, semi-automatic pistols, semi-automatic shotguns, but you cannot take physical possession of any of them without first completing the mandated training and receiving the state-issued permit. The training course must run at least 4 hours and cover safe handling procedures, storage requirements, Colorado-specific gun laws, and include a live fire qualification component. And here's why this matters critically for concealed carry holders. If you already possess a Colorado concealed carry permit, you're exempt from this new requirement. Your CCW permit satisfies the training mandate. But if you don't have a CCW permit and you want to purchase a semi-automatic firearm after August 1st, you must complete this training before you can take the gun home. The training costs between $75 and $150 depending on which provider you use, and that's just the beginning of the financial extraction. If you're currently living in Colorado or planning to move there, here's what you need to understand about how this system actually functions. The law grandfathers existing owners. If you already own semi-automatic firearms in Colorado before August 1st, 2026, you're not required to obtain the permit retroactively. But if you want to buy any new semi-automatic firearm after August 1st, you must complete the training beforehand. And here's the part that reveals the real intent behind this law. The permit is valid for 5 years. After 5 years, you need to renew it by taking a refresher course. This isn't a one-time educational requirement. This is an ongoing compliance system that puts the state in permanent control of your ability to purchase firearms. The training must be conducted by a state-approved instructor, and Colorado is currently in the process of certifying these instructors. The official list will supposedly be available on the Colorado Bureau of Investigation website by June 1st, 2026. Make absolutely certain you're taking this course from an approved instructor, because if you're not, that training won't count toward the requirement and you'll have to complete it again while paying twice. If you live in Colorado, here's your immediate action plan. If you already have a concealed carry permit, you're covered and don't need to do anything additional. If you don't have a CCW permit and you're planning to purchase a semi-automatic firearm after August 1st, you need to start researching approved training courses right now, not in July. These courses will fill up rapidly as the deadline approaches, especially in June and July 2026, and if you wait until the last minute, you might not find available slots. Now let's discuss the legal consequences for non-compliance, because this is where the state will hammer people. If you take possession of a semi-automatic firearm without completing the training and obtaining the permit after August 1st, that's classified as a Class 2 misdemeanor under Colorado law. You're facing up to 120 days in jail and a $750 fine. And the gun dealer who transfers that firearm to you without verifying your permit possession faces the exact same penalty, which means dealers are going to be extremely strict about checking for this permit starting August 1st. They're not going to risk their licenses and criminal charges because you forgot to bring documentation. This is registration through bureaucracy, and it's a model other states are watching closely. But if you think Colorado's training mandate is concerning, Kentucky just implemented something far more dangerous to due process, and it's already active right now. On February 1st, 2026, Kentucky's Extreme Risk Protection Order law took effect. This is commonly called a red flag law, and it's now been active for 2 weeks. This legislation passed the Kentucky legislature in March 2025 and was signed by the governor in April. Kentucky became the 22nd state to enact a red flag law, and it's one of the most expansive and aggressive versions we've seen anywhere in the country. Here's exactly how this system operates. Family members, household members, and law enforcement officers can petition a court to issue an extreme risk protection order against someone they believe poses a danger to themselves or to others. If the court grants that order, the targeted person must surrender all firearms within 24 hours. Their concealed carry permit is immediately suspended, and this entire process can happen before you even receive a hearing to defend yourself. Let me be absolutely clear about who has the power to file an ERPO against you in Kentucky. We're talking about current or former spouses, anyone you've lived with at any point in the past year, family members by blood or marriage, anyone you've dated within the past year, and any law enforcement officer who decides you're a risk. That's an incredibly broad list of people who can trigger this process, and the standard of proof required for an emergency ERPO is reasonable cause to believe, which is an extraordinarily low evidentiary bar. Here's why this should terrify anyone who values due process. If someone files an ERPO against you, your concealed carry permit can be suspended immediately, within hours, even before you know an order has been filed against you. You don't receive advance notice. You don't get a phone call warning you this is coming. The first indication you might have that your rights have been stripped is when law enforcement officers show up at your door demanding you surrender your firearms within 24 hours. You have 1 day to comply from the moment you're served. Now, the state will tell you that you do get due process eventually. Within 14 days of the emergency order, you're entitled to a full hearing where you can present evidence, call witnesses, and offer testimony in your defense. But during those 14 days, you have 0 firearms and 0 concealed carry rights. You've been stripped of your Second Amendment rights based on someone else's petition, and you're fighting from a defensive position to get them back. And if the court makes the order permanent at that hearing, it can remain in effect for up to 1 year. After that year expires, it can be renewed if the original petitioner files again, creating the potential for indefinite rights suspension. So, what do you do if you live in Kentucky right now, with this law already active? First, understand exactly who has the power to file an ERPO against you. If you're currently going through a divorce, involved in a custody dispute, or have had significant conflicts with family members, document absolutely everything. Keep detailed records of all communications, identify witnesses to your interactions, preserve anything that could refute false or exaggerated claims about your behavior or mental state. Because once an ERPO is filed, you're immediately on defense, fighting to prove you're not dangerous rather than the petitioner having to prove you are. Second, if an ERPO is filed against you, hire an attorney immediately. Do not attempt to represent yourself at the hearing. This is not comparable to fighting a traffic ticket or a minor civil matter. This is about your fundamental Second Amendment rights and your ability to possess firearms potentially for years. You need a lawyer who specializes in firearms law or civil rights litigation, and you need one fast because that 14-day hearing deadline is coming whether you're prepared or not. The legal consequences for violating an ERPO are severe and designed to terrorize people into absolute compliance. If you possess a firearm while an ERPO is in effect against you, that's classified as a Class D felony in Kentucky. You're looking at 1 to 5 years in state prison. And even after the order eventually expires, you must petition the court to get your firearms returned to you. They don't automatically come back. The state keeps them until you prove you deserve them back, inverting every principle of American justice. Meanwhile, there's one federal proposal that gun owners keep hoping will solve the interstate reciprocity nightmare, but that hope is dangerously misplaced. The Constitutional Concealed Carry Reciprocity Act, known as H.R. 38, was reintroduced in the House of Representatives back in January 2025. If this legislation somehow passes, which remains a massive if, it would force all 50 states to recognize concealed carry permits from every other state. This would represent the single biggest change to concealed carry laws in American history, and gun owners have been fantasizing about it for years. Here's how it would theoretically function. Right now, concealed carry reciprocity is a chaotic patchwork of state agreements. Texas recognizes permits from 42 states. Florida recognizes 38 states. But California recognizes exactly 0 out-of-state permits. New York recognizes almost none. New Jersey recognizes none. So if you hold a Texas concealed carry permit and you drive through New Jersey with your firearm, you're committing a felony under New Jersey state law. If H.R. 38 somehow becomes law, your concealed carry permit would work everywhere, functionally the same as your driver's license. Your Texas permit would be valid in California. Your Florida permit would be valid in New York. Your Arizona permit would be valid in New Jersey. States could not impose additional requirements or restrictions on out-of-state permit holders. They would have to recognize your permit, period, end of discussion. Now here's the current status, and this is where reality crashes into hope. H.R. 38 passed the House back in 2017, then died in the Senate without even getting a vote. It was reintroduced in 2025 with 213 co-sponsors in the House. That's nearly half the House membership supporting it on paper. It's currently sitting in the House Judiciary Committee. If it manages to get out of committee and passes the House again, it moves to the Senate. And that's where everything falls apart. The Senate is where this bill goes to die, just like it did in 2017. Why does this matter for you right now? If you travel across state lines with a concealed firearm on a regular basis, H.R. 38 would be genuinely life-changing. Right now, you need to check reciprocity agreements every single time you cross a state border. You might need multiple non-resident permits just to cover your normal travel routes. If H.R. 38 actually becomes law, you'd need one permit, your home state permit, and you'd be legal everywhere. But here's the critical warning that too many people are ignoring. Do not assume this is law yet. Do not assume it's going to become law. It's still sitting in committee. It hasn't been voted on. Even if it passes the House, it could die in the Senate exactly like it did 7 years ago. And even if it somehow passes both chambers and gets signed by the president, multiple states will immediately challenge it in federal court, creating months or years of confusion about enforcement while litigation proceeds. So, until you see this signed into law by the president and surviving the inevitable court challenges from blue states, continue following current reciprocity agreements as if H.R. 38 doesn't exist. Check the status of H.R. 38 regularly if you want, but don't plan your life around it. If you travel interstate frequently, consider obtaining non-resident permits from states with broad reciprocity. Florida, Utah, and Arizona are the big three that give you the widest coverage. And always, always check reciprocity maps before you cross state lines with a firearm, because the consequences of getting this wrong are years in prison. So here we are in mid-February 2026, and the landscape has fundamentally shifted while most gun owners weren't paying attention. The NFA tax stamp fee disappeared on January 1st, but the federal registration and control system remains fully intact, and anyone who thinks they can skip registration because the fee is gone is heading for a federal felony. The federal sentencing guidelines changed back in November 2025, more than 3 months ago, doubling penalties for straw purchases to 10 years and increasing penalties for lying on Form 4473 to 5 years. And the ATF is actively building cases right now using database cross-references and social media monitoring. Colorado's mandatory training requirement takes effect August 1st, 2026, less than 6 months from now, requiring anyone purchasing a semi-automatic firearm to complete state-approved training and obtain a permit that must be renewed every 5 years, with criminal penalties for non-compliance. Kentucky's red flag law went active on February 1st, 2 weeks ago, allowing ex-partners, former roommates, and anyone you've dated to petition for an extreme risk protection order that strips your firearms and CCW permit within hours before you ever get a hearing to defend yourself. And H.R. 38, the concealed carry reciprocity bill that would solve the interstate travel nightmare, is still sitting in committee in the House with no guarantee it passes the Senate, even if it clears the House, meaning you cannot count on it and must continue navigating the current reciprocity chaos. Here's your immediate action plan based on where these changes actually stand right now. Mark these critical dates. January 1st already passed for NFA changes. February 1st already passed for Kentucky's red flag law. August 1st, 2026 is coming fast for Colorado's training mandate. The federal sentencing changes have been active since November 1st, 2025, and are being enforced right now. Check whether your state is directly affected by any of these changes. If you live in Colorado or Kentucky, or if you travel through these states regularly, you must understand these new legal frameworks, because ignorance will not protect you from prosecution. If you were planning to purchase NFA items, you've already missed the fee, but registration remains mandatory, and federal felony consequences remain unchanged. Never lie on Form 4473 under any circumstances, and never make a straw purchase for anyone regardless of your relationship, because the penalties just became drastically harsher, and the ATF is actively investigating these violations using every tool at their disposal. Gun laws are changing faster than at any point in modern American history, and staying legal now means staying constantly informed about changes happening at both federal and state levels. That's exactly why you need to subscribe to this channel right now. Hit that subscribe button and turn on notifications, because we're covering every major gun law change as it happens, not weeks later when it's too late to prepare. Drop a comment below and let everyone know what state you're in and whether you're affected by any of these changes, because the community needs to know what's happening on the ground in real time. Share this with every gun owner you know, because the mainstream media is not covering these enforcement timelines honestly or completely. They'll run a story when someone gets arrested, but they won't warn you beforehand that the law changed months ago. Next week, we're breaking down the ATF's latest regulatory actions and why gun owners should be paying attention to enforcement patterns, not just legislative headlines. Stay safe, stay legal, and understand that in 2026, the government is counting on your ignorance to turn you into a criminal. Don't give them the satisfaction.